Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next stretch on February 28, 2020, 7:44 p.m. How, does the FBI find people? The people's misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
Alrighty. Good morning, good afternoon, I think it is almost for most of you. Welcome to the Court of Public Opinion. I am the Recovery Addict. Showing you that it's still beautiful outside. Absolutely beautiful. We're filling the hot tub. I don't know what we're going to do once it's full because the thing doesn't work. No, we're trying to fill it and then clean it. Anyway, that's going on in the background. Welcome. We're about to kick off the Robert Tellis trial, day 5, part 1. Why is that this? Let's see. Oh, there we go. We have some chat. We have some people to recognize in chat, specifically Keisha Pickrell. Congratulations. You are first in chat. I call you Katia. I can't remember if it's Keisha or Katia. I think it's Keisha. Welcome. The seats aren't working yet. Let me make sure that we'll just buzz the butler really quickly. I'll get those up here. Let's see. Of course, the link went away. There it goes. Okay, it's loading right now. Slowly. It's attempting to load. Oh, it loaded over here. Why is it over there? Okay. No thanks. Won't update today. Let's move this one over here. There we go. Seats are working now. They'll kick in here in just a second. Congratulations, Keisha. Katia. Katia got justice today. First in chat. Katia. 3 easy syllables. And you didn't say it correctly. It's neither. Katia. I have the worst memory. I call my kids the wrong names. I call them names that are not even my kids. So, yeah, it's my fault. I'm sorry. My apologies. Congratulations, Katia. I think that's right. Red Pen corrected me, so Red Pen's always right. You were first in chat, so you have won the internet for the day. Congratulations. Keep it running for the rest of us. We're going to get caught up with court as long as you can keep it running for us. So please do that. Let's see, where's channel 2? Channel 2's there. Super source, box source 3 is 2. I need our counter. The burner phone's going off. Just 1 second. Case file in Discord. Sharon, I'm getting something in mod chat. I'm trying to figure out what it means. I'm not sure. If I'm doing something wrong, let me know. All right. I need to change the backgrounds. That's what it was. There you go. I need an extra media source. I need media 1, media 2, and media 3. And then we're going to turn on or tie the counter. There we go. Now we can take court and see that that this is what's happening in court, which is nothing. They're supposed to start in about 15 minutes. I'm going to take this down as a reminder that I messed up yet again. The internet's all yours, Katia. And please keep it running for us. That's all I'll say. Make sure you get your certificate of internet ownership to commemorate this decisive win is what it was. Answer the burner phone. It may be our chat mom. She can explain it. I missed it. It buzzed, and then I picked it up, and it stopped buzzing. My gran used to call us by the wrong names when we were in trouble. Eventually, she'd say, "You know your name," and continue scolding. Yes. It's the one I'm looking at. That's the one that's in trouble. Amber, might need your help, Amber, if you could. Looking for media access forms for Carly Gregg in Mississippi, or directions related to that. All right. Anything else? I think that's it. I was just going to get a couple different feeds going to get the audio where we want it to be. Let's see. That's camera 8, which is this guy. There's preview. There's 8. Okay. Oh, I think I was going to show the walk one more time. Give me just 1 minute. New trial date. We got that one. I don't know what's making that sound. Are you guys hearing that? Like a might just be in my headphones. I might just have a power cord running too close to an audio cord that's unshielded for some reason. But all right. Give me a second. We're trying to get everything put together. At least I am. You hear a cackle. Let's see if it's on my microphone. It's not on the microphone. It's not my lamp. I hear scrolling. Okay. We'll get set here in just a minute. We'll have everything for you. All right, channel 6. Let me get 6 sorted while we're doing this. Yeah, I'm going to have to reroute all my cables. I've got something buzzing. It's very quiet, and when everything else is quiet, I can hear it. And that's not okay. Found it. Found it. We had to... Yep, that's it. Okay, so the iPad power... The power cord for the iPad is not shielded, and it's giving me some problems. Luckily, there's 2 ways to do everything on this channel, so I'm going to fix that right now. There, it's fixed. iPad's powered through a different device, so it doesn't pass the hum. All right, this is my life. Yeah, this is my life. This is what I do. It's like, what's making that noise? Everyone else is like, what noise? It's like, you guys can't hear that? Yeah, it's just me. All right. There's tell us day 4. We need day 5 over here. I've got to get everything. I'm trying to set everything up right now so we can show you the the best video and the best audio at the same time. But first, we're going to go back and play a portion of something that we put together just a little bit earlier, which is the walk. The walk in question. This has to do with a video that was shot by RJ, the Review Journal, when they went and did an interview with Mr. Tellis. This was before the killing, obviously, because the reporter who was the victim in this case was doing the interview. So let's see if we can take camera 8 without the DSK. There we go. All right. So here's our video. This is my editor that I'm using. I haven't bothered to export it yet, but looping this through, you can see the walk. You can see how he has this unique sort of gait, a little swing. There's a little bit of a limp to the left, or to the right, excuse me. It's more pronounced on the video on the right. But it looks like a heavy step to the right that seems to match. That foot just seems to fall harder. Anyway, he does roll on one hip a little bit. Need to see him walking from the side. I can't tell from this video. Yeah, I would say this is not enough evidence to convict right here at all. This is not enough evidence. Even if they look very similar and can be matched up perfectly. That's not enough evidence to convict. It's circumstantial, and it was enough for somebody to be curious and say, hey, what happened here? But not enough evidence to convict for sure. Going back to court, we do not have audio yet. As soon as it does come in, we'll bring that to you, and so we'll get some hot mic moments, possibly. The gate got him. His friends who knew him very well, who associated around him and worked with him daily, saw that gate and said, I recognize that. Can't unsee the boxers now. His knees move out to the side a little. Ramona Flower says, this is wild. With everything combined, he looks very guilty. Yeah, what we don't have is a picture of him wearing this outfit. Caught on camera with a face that matches. We don't have that. We have in the picture, the shoes match. Okay. The pants are very similar. You can see, dark pants. That's why they confiscated the dark pants he was wearing when he was arrested. But clearly I don't think those were the same pants. He was wearing gloves. A whole upper body was covered all the way up to the neck. The head was covered with a low wide brim straw hat. And there's just nothing to see to match it up. So we have to use the shoes. We have to use the fact that the car matched his car and drove back to his neighborhood. We have to use the gate. We have to use the evidence that was found at his house, including the cut up straw hat, the cut up shoes, the bag that matched. We have to use all of that, and we also have to look at the fact that there was a very strong motive. But all this was planted, apparently, says the defense. Now, we're going to hear from the defense starting today. This is their case in chief. Picks up. Now, and for the record, I don't know if they're going to do anything. They might think that they've presented plenty of evidence just in cross-examining witnesses. I don't think that's the case. I think they actually will call people. But, oh yeah, we have to, I forgot. How could I forget, PJ? There was the small detail of the victim having the defendant's DNA under his fingernails, which is also, I guess, according to the defense, planted? What? They planted the specialist. Let's see. The DNA is pretty compelling evidence. Olimac says he's guilty as sin. No reason to give him a deal. I don't think a deal's on the table right now. But I imagine we will get at least one expert witness that's going to testify and sell their soul for whatever they say. But we've seen that in other cases as well. Should be a quick verdict, according to Brittany. I can't believe he took this to trial. It's crazy. I mean, it must be like, look at this face. Who do you believe, them or me? but I have to say them right now. Phone evidence yesterday was enough for me. The phone evidence had to do with images they found on his phone and his work computer of Google Earth of every single possible angle of the victim's house, of 150 pictures of cars as they passed along a route that the victim drove on. Yeah, it doesn't look good. Hope he takes the stand. If he does, it will be epic. Male Sarah Boone. Yes, I think I said that. I think he has a lot to say, and I've tossed this out already. I think we cannot rule out the possibility. First of all, because we know that he tried to be pro se before, of him not liking the way the case is going, the way his lawyers are handling it, and firing them mid-trial and running it himself. I think that is still, you have to keep that as an option. You can't close that off, especially if they disagree strongly on him taking the stand. A lot of people say he thinks he'll take the stand, or they hope they will. How can his attorneys say his defense theory with a straight face? Defense attorneys, it's fun to talk to defense attorneys. I really like it. They have I would say a different view of the justice system than a lot of us do. A lot of us might look at this case and say, "How can you defend this guy? He's guilty," and their view is, "That's why I'm defending him." Because the state, we still have to hold the state to their burden. The state has to prove these things. You've got to, we defend the little guy because he's guilty, to make sure that it's not, that he's not overpunished, that there's, that justice is done, but it's done properly according to the law. And if they don't follow the law, then you should not have the sentence. So their view is a little bit different of that, and that's how, I wouldn't say that's how they rationalize, but that's how they approach the situation. And it's interesting to get into depth in a conversation with defense attorneys about that. Okay, still trying to get all my ducks in a row here, so just one second. That's the wrong one. Minimize. Sorry, I can't click and read at the same time. There we go. This is the one we want over there. Just right here. Make that full screen. So that one's done. Now on to 6. Okay, so 2 and 6, 2 and 8 are ready. Now we just need camera 6 to be set up. And we got it. Beautiful. Closed captioning off. All right, now we're set to go. So on your bingo cards, how do you think the state? Who do you think the state is going to call first as a witness? The bold move would be to call Mr. Tellis right off the bat. That would be extremely bold. Any thoughts? Sorry, the defense. I said the state. The defense is the state has rested their case. It's on to the defense. I misspoke. Is the seal on the thumbnail? Can we please have a look? Right now, I've got all my screens doing other things, so I can't show you, but I can look myself. And I don't see the seal on the thumbnail. Let's bring in camera 8 as the source here. It's a better picture of the seal. Was the victim's blood on the shoes? Kim, I think it was his blood that was on his shoes. I think that was his blood because he had a finger that was bleeding, and he clearly probably took the shoes off and got blood on them. I don't think it was the victim's blood. But we do have the defendant's DNA on the victim's fingernails, which is, I think, a more compelling evidence. I think Jappe was the only one not released. Karen says, I'm a lunch lady, and today is my first day back at work from summer, prepping the kitchen and listening to RA. Wish I was in bed, though. I feel your pain. Sometimes there's just, you can't get enough sleep no matter how hard you try. Love that you're doing the good work for the kids at school, making the good food. Make them eat it, too. Don't just give them the cookie and the milk. They've got to eat the mashed potatoes. Katia says, Sharon, can I pass the internet to someone else? I'm not feeling too great at the moment, and I need to log off. I'm sorry. Sorry, everyone. Sorry. Hey, don't apologize. We can pass it on. You just have to point the finger of who is the guilty party, the recipient, and we will re-gift the internet appropriately. Abby J has volunteered. Sheena, wowzers, 10 months. Sheena, congratulations. Love it. 10 months. It's flown by. Wouldn't be the same without you here, though. Glad that you were able to be with us all this time. Boom. There it is. And like that, an ironclad legal transition has taken place, and the internet has now been transferred to Abby J. So Abby J is our internet winner today. Abby, thank you very much for volunteering yourself to be internet owner. Basically, all it boils down to is you're responsible for maintaining everything internet-related worldwide for the duration of this show until we go live again. So it's just going to be an hour or two, I think, and you're going to do great, I'm sure. Now that you're an internet owner, make sure you head over to the shopping tab on the YouTube page and download your own fill-in-the-blank version, a certificate commemorating your ownership of the internet, which is suitable for framing or use as a cover sheet on your CV. Zimmy from the bus stop gifted a membership. Thank you very much. Thank you very much, Zimmy. Appreciate your support. Lisa, your turn will come. I'm sure your turn will come. Katia, please get better. Get some rest. Get better. We need you in good health before verdict time. Abby says, I've been preparing for all 8 months. I've been a member of this channel. This is my sole purpose in life. Today is the day. Congratulations, Abby. Winning the internet is a tough thing. It is. It's tough. It requires dedication and fast internet and a lot of clicking. Let's see. And it's cheating, says Callie Mae. Greeners, I think she's looking at you. It's funny when an individual learns the secret of how to win the internet reliably. Then it becomes quite easy. Did RA figure out how to stop making a loss from the mugs? No, but I think the mug company stopped allowing me to place orders. They want me to re-authenticate my account or something. I thought it was a scam, so I haven't done it, but I think the mugs are not working right now. So I'm not sure if they ship if you order one. Marcy Combs has been here longer, but I love being here with you all. 7 months on the record, but we know that's more than that. Thank you very much, Marcy. Is putting the seal on the thumbnail going to get you in trouble? No, it won't. But as a matter of fact, let me do this. I just took a picture of the seal. Let me switch to this camera really quickly. I'll upload a picture of the seal for you to use. Let's see. Send this to. I've got a good version. That's why I'm doing that. Send it to the MacBook Air. There we go. All right. And it arrived. So now I just have to upload. Edit the image, remove the background. There you go. The seal is up. It's covering everything. I just stuck it on the front page because I'm lazy like that. But I guess I could resize it and put it somewhere, but yeah, I messed it up. I'll let you move it around. All right. Good thing the judge is late. She gave me time to finish approving books for distribution. Sounds good, Tracy Lynn. Good, getting some work done. Bite Me says, any new t-shirts coming our way? The Buttercup and I may want. I'm really bad at this, but if you make suggestions, I will try to get some made. Aria was not frozen. Aria was staring at the computer and deep in thought. Pretty eyes. I like it as well. It's a lot of fun. I called you Marcy. That's my bad eyes, Macy. I apologize. Krista, if you've ever won, even if it's been for a very brief live stream, you're eligible to receive the...
Gaddis's testimony. He was concerned about the anonymous tips, the number of people in reference to the anonymous tips. Certain conclusions that Detective Gaddis arrived in establishing her probable cause, and we would anticipate in basically roughly him testifying to the same thing as had been previously addressed before the court in our motion, in our renewed motion, since my being retained concerning the Franks v. Delaware motion.
Okay, and I do recall reading that report. You're not going to call him first, right?
No.
I mean, so at lunch I can review his report again?
Just cut right in with audio.
So I'm assuming the state's making a motion to not allow?
Yeah.
Okay, I just want to be able to review that report again.
Understood, and we had noticed him up as an expert witness. We have him available, and obviously we do this prior to the trial starting to see where the evidence is, the state of the evidence that's been presented by the state. He is available to testify. I've explained the concerns that the state has, and perhaps Your Honor would have with his proposed testimony, and we anticipate Your Honor wanting a proffer, but I've provided ahead of time his opinion by way of proffer so the court knows the sum and substance of his testimony.
Okay, and so you won't call him before the lunch hour then?
We will not.
Okay.
Sure. Okay. Your Honor, so we were, yesterday after court, we were provided with a series of proposed exhibits. The state has some concerns as to the admissibility as to a number of them. So our thought was maybe if we could address maybe some of the issues regarding admissibility now. What I didn't want to do is perpetually interrupt witnesses with objections on this. And certainly if we had had these a little earlier, we could have at least maybe brought these concerns up.
Who's your first witness?
It would be Dr. Mark Chambers. And what we would propose to the court, because this case has been moving forward so efficiently, a number of people are going to be available at the end of the week. We've been reaching out, trying to get people to move their schedules to be available today. There's been some difficulties in reference to that. What we anticipate doing is calling Dr. Mark Chambers this morning and then having a break so we could address these issues that should be addressed out of the presence of the jury to avoid an interrupted presentation of the defense's case.
Okay, so you're only going to have one witness today?
Correct. As of right now, we're waiting for another witness. She had called Crime Stoppers. She was available tomorrow. We're trying to move her up till this morning. We called the hallway. She is not present yet. Again, everybody was subpoenaed to testify towards the end of the week. So we're trying to accommodate the real-time schedule of this trial.
Might be a short day today.
So we could let the jury go, but we could deal with some of these exhibits?
Correct.
Certainly.
All right,
Whoa.
we don't have to do it before Dr. Chambers comes in.
No, we could put Dr. Chambers on.
Okay.
Judge, can I have the evidence proposal so I can make a record of what was being objected to?
Right, we could probably do that as a break.
The other thing is, I believe the defense will stipulate to the admission of 312 and then 316 to 336.
That is correct, and obviously the purpose of the stipulations is to make the trial process smoother and better presentation of evidence to the jury, and obviously we anticipate participation in the same way from the state concerning our exhibits. But yes, we stipulate the admission of those exhibits. I'm going to approach your clerk with our defense exhibits.
Okay.
Additional defense exhibits. I believe we're up to X.
So these are the ones the clerk's going to mark?
Correct.
Okay.
Okay, so we can make a record. We are, yes, we're on X right now.
And the only other thing, Your Honor, is remember how I talked about having a flash drive of the long form of all the video?
Right.
The defense raised a couple concerns. I'm just deleting the images they don't want on there to go back to the jury. I want them to check my work to make sure I remove what they wanted, and then we'll be offering that.
Okay. All right, can we bring the panel in?
Thank you. As far as the state's concerned, yeah.
All right.
Okay, so breaking news. We're going to have a short day today. Working some issues. The jury is going to be sent home after, I believe, one witness. Do they make t-shirts for dogs? Like dog-sized t-shirts? I think I actually might have a pet item on my channel. It seems weird that defense turned this over this morning, and the only thing that the state says is, yeah, we wish we would have got this sooner, but apparently they're not upset about it. A bunch of exhibits the morning of defense starting their case in chief.
Thank you all. Please be seated.
Does the state stipulate to the presence of the panel?
Yes, Your Honor.
And the defense?
Yes, Your Honor.
Okay, Mr. Droskowitz, you may call your first witness.
Yes, the defense calls Dr. Mark Chambers.
Dr. Mark Chambers, first witness for the defense. Give me just a minute. We're going to transition to this right here. We're backing up just a tiny bit.
Thank you. All please be seated.
Does the state
Backing
stipulate
up
to the
just a
purpose
tiny
of the
bit.
panel?
Yes, Your Honor.
And defense?
Yes, Your Honor.
Okay, Mr. Jaskowitz, you may call your first witness.
Yes, the defense calls Dr. Mark Chambers.
Helps me to get the audio better.
If you please remain standing, doctor, and raise your right hand, face the clerk.
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may be seated.
Thank you.
Please state and spell your first and last name for the record.
Mark Chambers, MARKCHAMBERS.
Thank you. Dr. Chambers, if you could begin by telling us a little bit about yourself, beginning with your education.
All right. I attended undergraduate studies at Stanford University, where I graduated with a major in psychology and a minor in biology. I graduated with distinction, which meant that I was in the top 10% of my class. I also was admitted to Phi Beta Kappa during that time. I also earned a master's degree at Stanford in education. My doctoral studies were conducted at Northwestern University, where I earned a degree in clinical psychology.
How are you currently employed?
I am self-employed with a practice in clinical and forensic psychology.
If you could please explain to us the difference between clinical psychology versus forensic psychology.
Clinical psychology is probably what most people think about when they think about psychology or psychologists. A clinical psychologist deals with problems in the human condition, mental disorders, or other kinds of personal problems people may have in their lives, like depression or anxiety. They do psychological testing to help better understand a person's issues or problems or situation, and then they provide treatment services, which we usually refer to as psychotherapy or counseling.
If you could explain to us, too, a little more in detail what is psychology. I think we all have a pretty general idea, but if we could just address that this morning.
Psychology is the science of behavior, and although most people might think of it as relating to thought processes or something that goes on inside the brain, that's not something that we can access directly with any kind of psychological or scientific methods. So we have to look at people's behavior, and then from that we sometimes infer things about the way that the human brain works or why people behave the way they do, but ultimately we are looking at behavior and then drawing conclusions from that.
In reference to forensic psychology, which you have been qualified in previous hearings to give expert testimony concerning, is it fair to say that psychology is basically taking well-accepted principles, scientific principles concerning human behavior and applying it to specific circumstances?
Yes, and those specific circumstances are related to some sort of court issue. So a forensic psychologist may do work in family court, conducting evaluations or child custody assessments. They may work in criminal courts like this one here to provide expert testimony that might help the trier of fact, either the judge or the jury, to understand a particular issue that's germane to the case. Sometimes we also work in lawsuits and provide testimony about maybe in a car accident what kind of psychological trauma an individual has sustained. But ultimately, as you said, forensic psychology is the application of basic psychological principles and research to the issue at hand in the court-related proceeding. And as a result of that, a forensic psychologist sometimes has to be a little bit of a jack of all trades, because there are a lot of different areas of psychology that can apply to a court-related setting, and so we have to know a little bit about a lot of different things.
Okay, would you kind of, I guess, analogize that to that of a coroner? I mean, a coroner is called upon to give an opinion concerning manner of death.
Certainly, yes. A coroner has to know about head injuries and gunshot wounds and blunt force trauma and poisoning and all different ways of death that somebody might experience. So they can't be an expert in any one of those areas. They kind of have to know all of those things so that when they perform an autopsy, they can bring that knowledge to bear to determine the cause of death.
So we have scientific principles applied to specific fact scenarios that help judges, juries make certain determinations concerning issues of fact. Fair to say?
That's fair to say, yes.
You've given and been qualified to give testimony concerning eyewitness identification. If you could, and other matters, if you could please explain to us other areas in which you have been qualified and given expert testimony concerning.
Sure. One of the big things that I often testify about has to do with the reliability of memory, because a lot of court proceedings rely on the testimony of witnesses, and by virtue of that, the reliability of their memory as to what they observed or experienced, or what kind of testimony they're bringing to the court. So there's a lot of research on how memory works, the way in which it can be defective, and that can be helpful to the trier of fact to judge the credibility or reliability of a particular witness's testimony, rather than just assuming that whatever they say is automatically true. I've also testified about the effects of various medications or substances on behavior, including drugs and alcohol, because those things can distort the way people behave, the way that they think, the way that they react to certain situations, and so that can be helpful to know. Stressful situations, trauma can also affect a person's behavior and reactions to certain situations, and so it can be helpful for a trier of fact to know more about that before making a judgment about the case in front of them.
And just so I'm clear then, you've been qualified to give testimony as a forensic psychologist, and as a forensic psychologist, your testimony could address a whole myriad of situations that affect people's behavior and why they do things.
That is correct, yes.
You have been called on in prior cases by defense counsel,
yes,
myself included.
Correct.
Have you been called upon to give testimony as a forensic psychologist in prosecutions?
I certainly have, yes.
Federal cases, state cases, if you could please explain to us just briefly your involvement in prosecutions.
I've testified and consulted all over the world, and I think if I had to add them up, the number of prosecution versus defense cases is pretty evenly matched. But I've testified in family court, I've testified in civil court, I've testified in military and federal courts, as I said, in many, many jurisdictions.
And when you're called upon, let's say, by a defense team or a defense attorney, you are not retained to give a specific opinion, fair to say?
No, I'm here
defense-oriented or prosecution-oriented, something like that.
Correct. I'm here to elucidate the relevant psychological principles and research and knowledge that will help the trier of fact better understand a case. In some cases, it's not favorable to the party that is consulting me, and I have to tell them, I'm sorry, I can't help you because the research says this, and that's probably bad for your case. And that's okay. I mean, sometimes that means a little loss of work, but I've got plenty of work, so that's not really a concern for me.
In reference to these scientific principles upon which you draw opinions or conclusions, you're not a research psychologist.
I am not. I mean, I was trained in research. I have done research. But in my role as a forensic psychologist, my primary skill is understanding research, being able to read research studies that have been published by other researchers, and then gleaning from that the appropriate principles and understanding about human behavior that's relevant to the case.
And these research studies, again, fair to say, cover a wide array of circumstances.
Correct.
Your job is to review the research. And let me ask you this, the research, whether it be concerning false confessions, whether it be concerning memory, it's open to peer review. And if you could explain that to us.
Sure. So the peer review process is a safeguard to make sure that research that is published has done the things that it needs to do to be reliable. So if a research team conducts a study and then they coalesce their findings and then they put together a paper or an article that they'd like to publish, they then submit it to the journal that they would like to publish it, and then that journal sends the draft of the study to a couple of other experts in the field who then look it over, they critique it, they make suggestions of what things could be done better or questions that they feel like they have that the study doesn't answer that need to be answered in the study. And in most cases then the study, if the editor of the journal feels like it still has merit despite the criticisms, it will send it back to the researchers with the suggestions and say, hey, can you make these changes and we'll take another look at it. Sometimes they'll accept it or reject it immediately, but most of the time it's that middle ground where they try to give some guidance to the researchers on how the paper can be better and more suitable for publication. So by the time a study gets published in a scientific journal, in a peer-reviewed scientific journal, it has been looked over by several sets of eyes, not just the researchers who are submitting the paper.
When you're called upon to give expert testimony concerning issues in the case, sometimes you're called upon to give a wide variety of opinions, and sometimes you're called upon to give a very narrowly tailored opinion as to perhaps a single topic or
Yes,
subject.
I think that's fair to say.
And in this case, you were retained to give testimony in the state of Nevada versus Robert Tellis.
Correct.
Did I reach out to you in reference to this case?
No, I believe that I was originally retained on this case by the defense investigator.
Okay, and that was prior to my involvement, to your knowledge, in this matter.
That's my understanding, yes.
You were called upon to review certain evidence in this case to give testimony concerning suicide attempts for those that are involving charges or facing charges.
That's correct.
Let's talk about this. Individuals who may be charged with a crime attempting to commit suicide. How common is it?
Well, first of all, it's hard to say because there's a lot of people that go into custody, but it's not very common. I think it's fair to say that it's probably less than 1 in 1,000 suspects or defendants who are involved in the criminal justice system. So it's not particularly common, but it is more common than it is in the general public. So people who are involved in the criminal justice system do commit suicide or attempt suicide at a higher rate than the general public.
Are there risk factors that have been identified by peer-reviewed scientific research on this issue?
Well, yes. One of the risk factors that has been identified is the severity of the crime, the severity of the charge.
Did this expert do the study?
So if somebody is accused of a particularly severe charge, then the risk for suicide or an attempted suicide is higher.
Fair to say that the severity of a murder charge is about as serious as it can get?
I would think so.
Is an attempted suicide a reliable indicator of a guilty conscience?
Not necessarily, no.
And is that based upon research?
Yes.
And if you could explain this issue.
So in 2011, there was a study published of a very comprehensive research project where they looked at over 27,000 suicides that were committed by individuals who were involved in the criminal justice system. And then they compared those individuals to over 500,000 individuals who were also involved in the criminal justice system but did not commit suicide, so that they could identify, well, what makes these people a little bit different than the people who didn't commit suicide. First of all, I think it probably is obvious that individuals who came in with a mental health problem were already at higher risk, because those are the people that typically commit suicide. So it wouldn't necessarily have anything to do with whether they're being charged or not, but it's clear from the research that the stress of being accused of a crime, particularly a severe crime, as I said, can cause people to commit or attempt suicide, whether they're guilty or not.
Oh, that's the part they wanted.
The study that I referenced, for instance, found that there were people who had gone through the system, were adjudicated not guilty, and after their case was done, they were still at a higher risk for suicide. Other people who had their cases dropped but had still been accused of this crime were at a higher risk for suicide. So it was clear from the study that it's more the process of being involved in the criminal justice system, being accused of a crime, that produces the stress that can result in suicide than guilty conscience itself. And I should add, part of the problem that even addressing that question of guilty conscience is that, remember I said earlier about what psychology is and it isn't. It's about behavior, it's not about mental processes. So to accurately answer that question, we would have to know what's in the brain of the individual. Guilty conscience, by definition, regards what's going on inside, not what the person is doing. And so there are going to be many, many cases where we don't know if the person is guilty or not. So it becomes difficult to answer that question.
You just stated.
But we do know that some people, even after they have been found not guilty by the system, just being involved in the system is a suicide risk.
Or maybe they were found not guilty and they were guilty and it was guilty conscience.
Upon to give testimony concerning the guilt or innocence of Mr. Tellis?
No, of course not.
That's obviously within the purview of this jury and not yours.
Absolutely.
So just so I'm clear on your testimony, if a person attempts to commit suicide after being accused of a crime, that doesn't mean that they probably did.
It's not a reliable indicator, no.
Innocent people, or people that have been exonerated of a very serious crime, have attempted suicide.
Yes.
You are aware that Mr. Tellis cut his arms pretty severely in this case?
I am.
Did you have an opportunity to discuss this issue with Mr. Tellis?
I did.
Did he express to you concerns that he had at the time that he did this?
Objection, hearsay.
Was his explanation to you consistent with the studies that you have just referred to?
Objection, hearsay.
It's hearsay.
Again, you have given testimony concerning these studies where a person gets accused, and as a result of the accusation and the process, not necessarily guilt, but the accusation and the process, that person attempted suicide.
Yes.
And that attempted suicide does not necessarily mean a guilty conscience.
Correct.
Thank you. I have no further questions.
Thank you. Good morning, sir.
Good morning.
Can I have some sort of overview of what you reviewed in preparation for your testimony this morning?
Certainly. I was sent the discovery from the case, which I believe included the police report, which essentially documents the investigative process that the police went through when they were assigned to this case. I think that also included some hospital records for the defendant, when he was hospitalized immediately after his arrest because of the injuries to his arms. I think I saw some photos that were related to the case, and I was also provided with medical records for the defendant during his time in custody at Clark County Detention Center.
Okay. And in terms of the police reports, you mentioned that you had we call it the OR, the officer's report. Is that what you're referring to?
I believe so, yes.
Okay. How about any witness statements? Have you reviewed any of those?
I believe there were witness statements in there as well, yes.
Okay. And then did you review photographs associated with the case?
As I mentioned earlier, yes.
Video?
Don't recall seeing any video.
DNA reports?
You didn't see any video?
I think I saw some DNA reports, yes.
Reports from like phone extractions, anything like that?
I haven't seen any of the evidence.
I think I saw
oh, man.
a log of some phone records, so I'm not sure if that's what you're referring to.
I'm talking more like the contents of a phone?
I don't recall seeing that, but that doesn't mean I didn't.
Okay. And when was it that you were provided these materials?
It was some time ago. I was retained on this case, I believe, late last year, but I couldn't tell you the exact date.
Okay. And it sounds like you interviewed Mr. Tellis at some point?
I did.
When was that?
I actually interviewed him twice. I interviewed him earlier this year, I believe, and then I also interviewed him last Saturday.
Okay. And in either interview, did you record your conversation with him?
I did not.
Did you take notes?
I did.
Are your notes available?
Well, I'm not sure what you mean by that.
Well, do you still have your notes?
Yes.
Okay, so if the court ordered you to provide them, you could do that?
I could, yes.
Okay. And you understand, of course, we don't have them yet.
I haven't been asked for them, no.
Okay. And so if we made that request and the court agrees with us, you'd be able to provide it?
Certainly.
Okay. Besides Mr. Tellis, did you interview anyone else?
I did not.
How long were the interviews that you conducted with him?
The first interview was about 3 hours, I believe, and then the more recent one was maybe an hour and a half.
Okay. Did you ever administer any tests to him?
I did not.
So it was just interviews, and so you're sort of relying on his description of events?
Well, I mean, I captured his description of events.
Okay. But what he's telling you is his factual version, right?
I would assume so.
Okay. I mean, you don't ever verify that with anybody else. Is that fair?
I have not.
Okay. And so you're kind of getting information from a single source?
Well, I'm getting information from him for the information that he has available to him.
Okay, and like you could apply, I mean, sometimes there are tests administered in order to do psychological assessments of people?
Correct.
And none of those were done?
No.
On either occasion?
No.
Okay. And you're not here to tell us anything about events that occurred on December the 2nd of 2022, correct?
Well, no.
I mean, you haven't
on that date. No.
You haven't been to Bronze Circle.
Counsel, I believe it's September 2nd. There was a question. December 2nd. I think.
Oh, I thought I said
Just a
September.
mistake.
I
No
apologize. I mean September. If I misspoke.
Yes. No.
I mean, you haven't been to Bronze Circle.
No.
You're not familiar with any of the evidence other than what you read in the officer's report?
Whatever I read in the police report, yes.
Okay. Now, you mentioned that you sometimes testify like about the reliability of memory and that sort of thing, and that is sometimes used in cases where there is eyewitness testimony to be relied upon?
Yes.
And then sometimes I would assume it's to talk about like children who recall instances of sexual abuse that occurred in the past. They're challenging their memories of that.
That's right.
And so you kind of provide, I guess, context to how they might misremember things.
In some cases, yes.
Okay. And I think you said on direct examination that that going through the criminal justice system just in itself is a stressful event,
Yes, certainly.
and that correlates with the severity of the charge.
The risk of suicide correlates with the severity of the charge, yes.
Okay. And what we're saying is, I think you said it doesn't, I think your words were not necessarily when asked if it was like the suicidality was indicative of a guilty conscience, correct?
Yes.
And so not necessarily to me means sometimes it could be?
Sure.
Okay. So there are sometimes people are suicidal because of feeling guilty about the crime they've committed?
I think that's almost certainly true.
Okay. Do you have any kind of information, I don't know if there are studies on that, about how often that might be the case?
Well, because, as I said earlier, we don't know what's going through a person's mind in most cases unless they tell us.
Right.
People that commit suicide don't usually have much to say.
Right, but if you attempted it, you would.
Right, and even when they tell us, we can't always rely on that as being accurate. So it's a very difficult
You don't trust your single source of information?
Directly through scientific study.
Because people who have attempted suicide may be unreliable narrators about why they did things, right?
Absolutely.
And they may be self-interested when they're relaying events to you.
For sure.
And they may be motivated by sort of wanting to avoid criminal responsibility when they're talking to you.
Yes, definitely.
All those factors are always at play when you have someone charged with a crime. Would that be fair?
They can be.
Okay. And do you think there's a correlation of suicidality when people, like in high positions in society, have what's called like a fall from grace? Do you know what I mean? Being publicly embarrassed?
Yes. I think that that's probably a factor, because when I talk about the stress of being accused of a crime, whether or not you did it, there are a lot of factors that play into that. There's family, there's friends, there's finances, there's your employment, but also, as you said, if it's somebody who has a prominent position in society, just the public scrutiny of being accused, whether you're guilty or not, is sometimes inescapable. And we see cases of that all the time where people are accused of a crime, they're tried, they're found not guilty, but that scrutiny, that public scrutiny continues. Not everybody accepts a not guilty verdict, and so it can be very difficult to function in society afterwards.
But that public scrutiny would still exist, and the embarrassment would still exist if you were guilty too, right?
Right.
And if, say, you were the subject of really negative articles that were published countywide, that would be a stressor that someone might experience as well, right?
Correct.
Being accused of inappropriate behavior in the workplace would be a stressor for somebody, right?
I would think so.
Being accused of being a bad manager would be stressful for somebody, right?
Almost certainly.
Okay. And sort of being accused of being kind of incompetent at your job would be a stressor if that was something that was like published to, say, the county.
Yes.
Wow.
Okay. And those types of things cause stress on individuals that may or may not manifest as suicide, but they're troubling to individuals to experience. Is that fair?
Sure. Some more than others. It's all about personality and experience, but yes, I would think generally that's true.
And when you say some more than others, if they're someone who puts a lot of importance on their role in a particular office or status, it would be more upsetting for that type of person to have maybe negative articles written about them?
I would think so, yes.
Okay. Could I have the court's indulgence?
Wow.
Thank you.
Just very sweetly and nicely just dismantled the entire
Based upon your testimony and your opinion, there's not really this correlation concerning more evidence against someone for a serious crime then results in a higher likelihood of suicide.
I'm sorry, could you rephrase that?
Absolutely. So there was questions that you were asked concerning evidence in a particular case. And are you able to say there's any correlation between, let's say, the more evidence of a person having committed a crime, that being correlated to the higher likelihood of suicide?
Do you hear the
I think it's probably more accurate to say that it comes down to the individual's perception of his situation. So, for instance, if someone believes that they're in big trouble, that the cops have them dead to rights, whether or not they're guilty, that probably produces more stress than somebody who thinks, I can get out of this, or I'm good, or they don't have anything on me. So the objective status of that person's situation is probably less important than the subjective perception of the situation that they're in.
So again, that underscores, obviously you agree that human beings, we can be fairly complex and our behavior can be fairly complex.
That's pretty obvious, yeah.
It is, and oftentimes people think, well, if this person committed suicide, if he committed suicide, he must have committed the crime. You're here to dispel that common view.
Yes.
And there's actually scientific data that does so.
Right.
Thank you. I have no further questions.
Any cross?
Nothing else, Your Honor. Thank you.
Okay, Mr. Hawks.
Is this the only witness we're going to get today? That was crazy. The defense asked, is there any correlation between having a mountain of evidence against the client and the higher risk of self-harm? Defense acknowledging there's a mountain of evidence against their client. Trying to gracefully ask that question. Jury questions. Jury questions, yes. Labman, good eye. This is a jury question right now. Love the Uno reverse card mention. The witness had, plausible deniability, has not seen all this.
We have a question from a juror has been marked as court's exhibit number 15. Has anyone in your experience ever attempted suicide in an attempt to gain sympathy from being accused?
I think that's almost certainly true, yes. Especially when the suicide attempt is not successful. Sometimes people do what we call suicidal gestures, which just refers to the fact that it kind of looks like a suicide attempt, but it wasn't fatal. And in many cases, people do that just to garner sympathy or to deflect attention from some other issue that they're concerned about.
That would be the Murdaugh situation, right?
I do, thank you. And in reference to this, and we're not saying that's necessarily the case in this case, are we?
No, I'm not at all.
And this perhaps deflection, this perhaps attempting to get sympathy doesn't necessarily equate to knowledge of guilt or guilt.
No, it definitely does not.
Thank you. I have no further questions.
Oh my goodness.
Anything else?
No, Your Honor. Thank you.
Okay. Dr. Chambers, thank you very much for your testimony here today. You may step down.
Thank you, Your Honor.
May stop billing now.
Thank you very much for being here.
I'll step outside to see if our next witness is available.
Okay, we're hoping the witness showed up here. There's a witness that was subpoenaed to be here right now. I think she's the only other one. I think I'm saying she. It might be a he. There was, I believe, we heard before trial started that there was somebody who had called Crime Stoppers with a tip of some sort. It sounds like we're chasing our tail. The state has arrested. This is the defense's case in chief. That was their first witness, was that doctor. I hope he came with the money-back guarantee because it sort of got flipped on them right there at the end. And they were trying to just scramble and pick up the pieces. Not very good, I think, for Mr. Tellis.
Our next witness is not here, and as I explained to the court, we had them set for later in the week. We'd anticipate our next witness being available after the lunch break, Your Honor.
Oh, okay, this afternoon?
Correct.
Okay. So at this time, we are going to break for lunch. During this recess, you're marched on to discuss or communicate with anyone, including your fellow jurors, any way regarding the case or experience, either by voice, phone, email, text, internet, or other means of communication or social media. Read, watch, or listen to any news or media accounts or commentary about the case. Do research, consult dictionaries, internet, or reference materials. Do any investigation, test a theory, recreate any aspect of the case, or in any other way investigate or learn about the case on your own, or form express any opinion regarding the case till it's finally submitted to you by 1 o'clock.
The reporter in blue is Vanessa Murphy.
Any other issues that we're
Sure.
going to address?
Okay, so we'll be in recess till 1:30. Thank you very much.
USA. All right, so recess till 1:30. That gives us an hour for lunch. I know we just had a little break, but we're going to take an hour lunch break because I have to turn off the water in the hot tub because it's probably overflowing right now. Quick, just a little recap of what we just saw. The defense, in questioning this witness, was it psychologist or psychiatrist? I forget which one it is. Their psych witness, talking about behavior, not talking about what's in the mind. Is trying to say that they're saying, look, it's a problem. Optics wise, it looks bad that the defendant tried to take his own life when the end appeared near, meaning that he was about to get caught. And it's 2 hours. It's only 11:30. We have a 2-hour lunch break. Whoa. Psychologist. Okay, so it looks bad, and so this witness is called in to explain that sometimes people may resort to that, but it doesn't mean that they were guilty. Okay, that's his testimony. It comes down to, yes, he looked like he was trying to take the on my own terms way out instead, but that doesn't mean he was guilty. And the cross-examination dismantled that brick by brick. And just tore it apart and got him to agree the other ways that actually, yes, it is very likely that it also could have occurred because it was the consciousness of guilt that drove him to that end. And hearing the defense get up again under redirect and say, but there's no correlation between a defendant having mountains of evidence against him and the higher risk, is there? And he's like, excuse me, can you repeat that? But we're not saying that happened here, right? In this case, it was funny to watch that play out. I hope he wasn't paid too much, because that witness did no study of his own, did no analysis or testing of the defendant of his own. He just read someone else's report and testified about it, which I guess technically he can do as an expert witness, but it didn't give his testimony the sense of validity or weight that I think the jury would need if this were to be an effective witness to convince them of the defendant's innocence. So once again, the defense, I think, comes up with a 0, and the state has another win. All right, so we have a delay right now because this court is moving ahead faster than anticipated. The trial is going faster than anticipated, which means we're probably going to be maybe, I would even say, mid to early late this week, be done with this case, this trial, and be in verdict watch, which is great. Loving it. Thank you very much, Trish. Thank you very much. 7 months there. Because of that, the subpoenas, because we just switched from the state to the defense, the subpoenas that were issued, they have like times on them. You have to show up at a certain time. Well, defense was expecting to get the case later in the week instead of, on a Tuesday, first thing in the morning, possibly maybe a Wednesday going forward. And so now they're trying to get those witnesses that are available, maybe might be local, might already be in town, and try to move them up to fill in this gap instead of just having some dead space. Courts don't like dead space in the calendar. And so our next witness is going to come in right after lunch. That may be the last witness for the day, and then we'll start seeing more witnesses later on in the week. But it's only supposed to be a 2-week trial, right? So it's going to be fast. Debbie says 2 hours is perfect. I have pre-op. It'll give me time to get back and watch the craziness that is the defense. Will Tellis testify? I think he will. Oh, man. Let's see. The weather outside is beautiful. I'm going to go out and enjoy it just briefly while I check on the hot tub and make sure it's not overflowing. Yeah, I think I hear the water running, and it's going to be full by now. Wish I had their work schedule. I tell you, Vegas has it in spades. They've got good food, plenty of things for entertainment, and apparently a work schedule that would make any banker jealous. Any thoughts? Psychosaurus Rex, just finishing the psych witness now. I will say psych is very challenging to testify on because it's so nuanced, but attorneys don't ask for nuance, and you rarely get to explain the depth needed. The weather outside is wonderful, is what it is. Big shout out to Weatherwatch. He's my, first of all, he's a great friend. He's a great moderator, and he's my podcast partner. He's beginning tonight, week 1 of a 12-week Citizens Police Academy to which he is the what was your official title? King and Big Kahuna or something like I forget. No, it's he ran the publicity side of it, the public information side of it, and the outreach. So loving that. He's an amazing person, by the way. If you don't know Weatherwatch, he has his own channel, which he doesn't spend much time on because he's always busy helping us here. But do follow him on YouTube. Let's see, CPA Ambassador. That's it. I knew it was the title. Then you got flags on the car, and you got like a chauffeur. That's all I knew about it. But police escort, flags on the car. You're going to do great. I can't wait to hear about it. We'll hear about it probably on the podcast because week 1 is the start of the new Citizens Police Academy, and we'll probably hear about updates about how that goes. And it's always fun to see behind the scenes with the police, especially when they're just answering all the questions that the public has about their jobs. So look forward to hearing about that over the next several podcasts. Next one is on Thursday at 8 p.m., as long as that's still good with you, Thomas. 8 p.m. Eastern, 6 p.m. Mountain, which is where I am. All right, we are going to... Sienna's Baca. My stepdad stole thousands of dollars from my brother and shot himself with a flesh wound to deflect and gain sympathy. This is straight out of what was basically alleged against Alec Murdaugh. A very similar thing, only, it was a little bit different. But still, possibly to gain sympathy. All right, so we are going to go to lunch. We are going to take a break. It is a longer break. We have 2 hours, which means we'll probably take an hour and a half. That means we come back at, we come back at 2. Is that right? 2 o'clock Mountain. That's 4 o'clock Eastern. I don't want to do much more jury hopping because I have all my camera feeds and audio sources lined up and tuned to the broadcast. And so court hopping does not work very well. Murdaugh may get a new trial. He may. Oh, hang on. We've got a spam risk. Wait. Guys, quiet. Hello?
Hello, this is Harry with Accident Claims Helpline. How are you doing today?
I'm doing okay.
I'm here because we have been reported about a minor road traffic accident happened to you within the last 2 years. As your compensation for accident is still pending. Hope you remember that.
I do. I drove away from it, and I didn't know that it got my plate. But yes, it happened. Hello? He hung up. Told him it was a hit and run. Apparently, they don't deal with hit and run insurance claims. But, okay, mental note, next time we don't do the hit and run one. We'll get further without that. All right. I have no chill in these calls. I'm ruthless. I go with the first thing that pops in my head as well. So it is beautiful outside. The hot tub's overflowing. It's time for lunch. It's going to be a little bit of a long break. We'll be back at 2 o'clock Mountain, 4 o'clock Eastern as we continue the day. It's probably going to be a short day as well. It's probably going to be a short day as well in the afternoon, just because the defense does not have many witnesses lined up for this early in the case. They weren't ready for that. I don't think they're going to rush, even if Mr. Tellis is going to take the stand. I don't think they'd rush him until they possibly lay some groundwork or cover some other bases and see if they actually want to go that route. But let's see. Recap on Tellis. Josh, you only missed one witness. This is a defense case. They brought the psychologist on who testified that, yes, we heard, the whole story about Mr. Tellis being unable to get out of the tub because he had, performed some self-harm on his arms. And the reasoning behind that was the whole testimony. He was saying, just because he self-harmed himself, that does not mean he's guilty. That was the expert's testimony. It was like, it's possible that it could have just been that he felt the pressure of the situation, even though he's not guilty, led to that. And the defense was able to rip that apart brick by brick and flip the witness in an effective way. I don't think it was very helpful to the defense now. Mama Bear of One says, I used to hand my phone to my husband, did this to our daughter when she was little, and let her go off on them about some tangent. Usually would encourage a particularly boring subject. You should use the Lally method on these callers. What, if any? Who, if any? That's a good idea, Karina. Can you remind me next time we get a call? Jessica, I would say the defense is prepared to question their witnesses, but they were not prepared for the state to arrest as early as they did. That was a little bit rushed. So let's see. You'll try. Thank you, Karina. I appreciate that. All right. With that said, we're going to take a long break. I do apologize. I can't, like I've told you, I can't do the court hopping because of all the audio tuning and setup that's involved, and I have to just redo it. There's just no easy way to go back. So we're going to have to take a long break. I apologize. We will be back on the flip side. I'll build the thumbnail so there's going to be a place for you guys to chat, but I don't have it built quite yet. Well, I might be able to build it now. Let's see. How fast can I do my job? Day 5, part 2, starting time. When's the starting time? It's going to be at 2 p.m. Mountain, 4 p.m. Eastern. Done. I built it. I can build the portal to it, but I feel bad sending you there knowing that it's not going to start for an hour and a half. Right? And we've already got a winner first in chat over there. All right. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better, and please stay safe till we go live again in about an hour and a half. As this Nevada court has a brief break in witnesses, and we have to take a long lunch as a result. But I've got the portal set up. Look at that. I'm going to be a real YouTuber. I'm going to be a real YouTuber one day. Got it all set up so we can portal over and have the conversation over there. I can't see the same cloud here in southern. Well, I'm looking sort of southwest. I think southwest of UKKD. But I'm going to be a real boy. All right. I think we said everything we need to say. You guys, it's going to be a fantastic trial. It's just warming up. I think defense has more juicy nuggets like the one we just got. We're going to have the Crime Stoppers witness, and that's going to be telling. Have a good lunch. Have a wonderful time. We'll see you guys on the flip side. Ready? Bye-bye.